No, CRP cost has to be paid in priority. That includes operating CRP cost.
No, no, no. Sir,
Hmm.
what I am saying is
Hmm.
during CIRP, you are supposed to pay the charges.
Yes, but
Now,
it has got accrued for cash flow issues. You have not
so
been able to pay.
I'm accruing it to be paid in
Yeah.
priority at the time of implementation.
Yes, yes.
Is that also a payment?
That also has to be
So
paid. That is item one of the plan anyway.
no, no, no. That is
Hmm.
also regarded as payment during CIRP. See, the CIRP is going on. Implementation will happen maybe, let us say, 6 months down the line. Okay, after
Yes.
the plan is approved.
Yes. Yes.
You are wanting to use the asset now.
Yes.
Today,
Uh,
if you do not
After
have cash,
takeover, right? After takeover.
so no, 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 no,
Ah.
no.
Uh,
I'm saying, let us say you have a road project,
hmm.
okay, and let's say you have a telecom project, let's say, okay,
Telecom project is easier to
and there
understand.
is a
Yes.
spectrum there, okay. You
Ah.
have to pay
Ah.
the spectrum fees and license fees and
Yes.
what have you.
Yes. Yes.
Okay,
Yeah.
now you have a cash flow issue during CRP.
Right.
Okay, the plan is yet to be approved. Plan is, the CRP is going on; it's halfway through. Okay, you have still 6 months for the CRP to get over. But
Right.
you have to use the spectrum now to keep the company as a going concern.
Yes.
Because of cash flow issues, you are not able to pay the spectrum fee right now, but you're willing to
Yes.
accrue it to be paid in priority.
Yes.
Will that be construed
No,
as
that
payment?
the no, because if you look at that section 3 of subsection 3 of section 14, this was brought in. That says very clearly that current dues have to be paid, otherwise disconnection can be done.
Correct, correct. So it's basically payment, it's not accrual. Accrual is not
It is
payment.
not a, yeah, yeah, yeah.
Yeah, yeah,
Yes.
okay.
But if
Sir, in
no,
fact,
if
my own case is that honorable
one
entire.
second, Devang, 1 second. If no adverse action has been taken because of non-payment, and if it is
Mm,
paid, then, yeah, that is a what is a gratis or uh, the grace of the authority that they have not disconnected it or stopped you from using it. They
mm,
will
mm.
they are not expected to do it after you are ready to pay. That would
Okay.
be arbitrary exercise of power. Yes, they will.
Yeah, correct. So let's move forward further.
So anyway, this is an enabler or a clarifier, both. Uh, Now, this is a bit of a issue, okay, in my opinion. This is subsection 6 under this, which is being introduced, and I will read this because this is important. Unless otherwise provided in the resolution plan, any claim against the city and its assets under any other law for the time being in force prior to the date of approval shall be extinguished. Okay, what it means is, of course, if the claim has already been filed, it is being addressed in the plan. So this is basically claims which have not been filed, but there is a right for that towards that claim. These are statutory claims, income tax, post assessment, or GST, or usually of that nature. Then this is providing for this. This is actually Ghanshyam Mishra being brought in by legislation effectively. Okay, that the clean slate as on the date of approval. And so this 6A and 6B basically address the litigations that continue to be made, even though Ghanshyam Mishra clarified, now they are law, or they are proposed to
Sir,
be law.
this doesn't clarify on ESIC and PF. We don't
No.
see any
PF,
clarity.
so PF it's been clarified. If you want to really understand PF, go back to the Joint Committee of Parliament, the proceedings at the time of enactment, before enactment of IBC. It is clear there itself. All litigation subsequent to that, after the enactment of IBC, are frivolous litigation, in my opinion. The law was clarified long ago. There is a separate para on this in that proceeding. What was there as a draft bill by BLRC and how it was amended by the Joint Committee and which became final law, why it was done so. drafting, one can have an issue that it doesn't really clarify, or some people can have a different opinion. But the intent was very clear on a representation by the EPFO and authority at that time. The joint committee introduced that, that it shall not be part of liquidation estate. Okay.
Sir, my point is on clarity. See, the trust money has to be going to the workers who have worked so hard. You cannot take away their rights. But my issue is on penalty and interest. On that specific clarification, if it comes, it will be great, sir.
Okay, there are two things actually: interest and penalty. The other way around. Okay, interest and damages. Uh, uh, so interest goes to the beneficiaries of the fund. It doesn't go elsewhere. Now, damages, people think that it goes to the government. It does not. The damages also go to the trust, and they go to meeting the expenses of the trust, which otherwise would be met from the funds or from the interest earned from the income. So, indirectly, all those things go to improve the return on the PFO, and the return is for the beneficiaries. Okay, so next one, we are going to section 33, and there is an introduction here of this is, of course, outcome of Bhushan. Okay, a revival of CRP under certain specific circumstances. Okay, so one more chance, the second bite at the cherry, so to say. Any comments on this? Should it be there or not there? If some people want to say anything about that.
Sir, we are getting uneasy with easy exit. How many CIRPs? 1, 2, 3.
Yes, especially when the first CRP drags on for 2 years, 3 years more. Why do you need one more bite at the cherry? But well, a lot of people think that liquidation is a dirty word. It is not, but okay. So the majority opinion is in favor of such a provision in the country. Okay, all people concerned. This 120 days is a cap put for the second, revived CIRP. Will it suffer the same fate as 180 plus 90? God alone knows.
Others may please participate. Ravi Prakash and I are maybe, of course, he's many years senior to me, but good friends. So I'm meeting after long. So maybe if we discuss, others may please participate.
Okay, now let's come to section 34. Okay. No, no. Now this is important for IPs.
Ganti, sir.
Okay. Yeah.
Sir, can we also discuss about Section 12A amendment before going to the liquidation provisions? There is some amendment in Section 12A also.
12A.
The timelines has been
Yeah,
changed.
1 second. 12A.
Yes,
12A was
amendment number 8.
so simple that I thought there is. See, unless, you know, if you want to suggest something, yes. If it is a welcome provision, there is nothing to discuss because that's for different forums. Na? I think we have completed many rounds of discussion on the amendment provision. Today we are about suggestions. That means
Yes,
any
sir.
Sir,
changes we
I
want.
have a suggestion on 12A, but it may
Huh.
not go with the general suggestions. I believe when it is creditors, it should be also operational creditors who should be approving. It should not be only financial creditors. So that is my feeling.
No, sir. Like earlier, after the EY also, the withdrawal was possible, but after the amendment bill, now they have like shortened the timelines. Only after the first EY, that can be done. So if any IP has any issue in that, that can be raised.
No, now the 12A requires that once admitted,
Yes,
even
sir.
if the COC is not formed, it cannot be withdrawn till the COC is formed and 90% is there. So that
Yes.
interim period of 30 days, no man's land, that has been taken away. That is the major amendment. The second one is that after first EOI, no 12A.
Hmm. Okay, sir.
So it basically shortens the period and
Yes.
I don't
Yes, sir.
think we
They have
have a
shortened
problem
the
with
period.
that. It should
Okay.
be open-ended because earlier there was a 12A in liquidation till NCLAT said, no, no, sorry, that is going a bit too much.
Yes. Okay.
Uh, okay. Yeah. Now this 34.4 is important because if the, now this is about action being taken against the resolution professional if the plan doesn't get approved. Obviously, only on the compliance issues, huh? Not the commercial part, approved by the adjudicating authority. So people need to be careful about what they do. Change of liquidator, nothing much. This was there. Okay.
So
A lot of
replacement, maybe I have a view that replacement, in whether it is section 7, 9, CIRP, IRP replacement or liquidators replacement, it shall only be from the list. It shall not be from anyone nominated by any of the creditors or COC. Second thing is, even from the list, it has to be from the list from top to bottom, not any name from anywhere. So maybe uh, any independence is not compromised. If there's a replacement, as it is in bankruptcy, it will be honorable adjudicating authority that will be appointing. And even over there, the registrar may not have too much of option. They have to go list serial number wise.
Okay, that is implementation. That was the intent when the first IBBA panel list came out, that they used to wait it and, put it in the reverse order. It was never followed. It is not followed. Okay. I
So
don't
let
think
it be
we can tell.
legislated so that the implementation is proper.
Legislature is not going to get into these matters unless, it's no point. We can't tell Parliament to do everything for us. For every complaint that we have, every issue, Parliament doesn't get into it anymore. They will get into the broader issues about the implement, and this is implementation issue. It is not about law. The law says that they should be independent person. Now, if the IP decides not to be independent, that is not a failure of the law. Okay. Yeah.
Sir,
Now,
just a minute,
Haji,
sir. This is Abhay Kumar.
Haji, boli.
I have one suggestion because this act is given to the select committee where MPs are there. So from their side, any kind of recommendation shall go. I mean, there is no restriction that this is implementation issue or act, means sections issue, means as per act, legal issues. They are free. They give suggestions on implementation part also as per their understanding. I have seen in many such select committee report, they give certain suggestions related to the implementation also. So many of the suggestions in our discussion has come up. I think we should
This has to
document
be
it and send
rectified.
it also.
Okay, let me, Devang, hold on. Let me ask a few, or rather make a few practical observations. We have about 6,000 odd IPs, roughly. Okay, 6,500 or so. How many would have even read the amendment bill in full?
No, maybe
Okay. Okay. Now you give a proposal which is only one page or less than one page, and you give a proposal which is 100 pages, which is going to be actually looked at. So we have a short window. We have to strike to the extent it is heard. And the more we talk of such implementation, see, an MP making a suggestion, you look at parliamentary debates. Now, especially the opposition, will make 200 suggestions. What really happens? Nothing gets approved. Okay. The fact is, so parliamentary member can say anything, and if you have access to somebody who will put up your this thing, that's fine. Here we are talking of an institution like the IPA representing the voice of its members before parliament. So we need to take that restriction into account and focus on those issues which really matter. I mean, which any common person would say, yes, isko dekhna chahiye. We can't be, telling our sob story everywhere. Hey, people don't listen to IPS today because for 7 years we have been crying. Mostly, whenever we have sessions, it is about my fee, my appointment, my this thing, my this thing. You know, the real issues, even if they are said, they get overlooked. So let us
Sir,
today's session.
we are going to the outcome. Means we think this will not happen. See that if that way we have to consider, then normally
No, we have a
IBPI,
limited
whatever
time
they draft
today.
it, they carry that
Abhayji,
only.
Abhayji, we have limited time today. Nothing prevents a member of the public to write directly to his MP or to the select committee. So let us now focus on whatever we have a limited time and make the best utilization of that and not make a laundry list. Okay. That's my only humble submission. I'm not saying don't say anything. I'm saying let's utilize the
No,
time in the best possible
there are
manner.
practical problem in IBC. I mean, and one of the culprit is the NCLT delay. So if any suggestions comes on how to shorten the delay and all, I think we should, because see,
How is
I
good, but only to say, oh, delay hai, they should do better is not a suggestion. It's a complaint. If there is
anyway,
any concrete
that is
suggestion of how it can be definitely implementable, makes life easier for the implementing authority, definitely yes. Okay.
In fact, if I don't know if that part was covered, I joined around 3-4 minutes late. Uh, on that in 14 days, the adjudicating authority should decide or give reasons. Maybe that amendment is not good enough without increasing the infrastructure, human and physical, of
That is not an
adjudicating authority.
amendment. Devang, infrastructure resources are the duty of the government. The government is failing in its duty. What can law do? Law says you should do it like this. Okay. But the parliament has the power to haul up the executive on implementation. That's their job, or the people have it by throwing out the government. What else can you do? Or you can have a writ. If it in certain specific cases, you can file a writ jurisdiction. But it's not about people. You think justice administration issues are a problem of today? 100 years ago also they were same. There's no difference.
Sir,
There
case
are deeper.
disposal, as we are discussing, case disposal timeline in India is only around 300 years. So NCLT comparing is super fast.
Yes, exactly. Now you hit the nail on the head. It is the best adjudicatory forum till date, at least in independent India. It's not good, but it is still the best. So we have a long way to go as a nation. Okay, this is about COC supervising the liquidation process, and the word supervise is used. Okay, important word. Okay, sections 38 to 42 are being omitted. Now these deal with claims during liquidation. It's all going away. So what happens? Can you file claims during liquidation? Not file? Those who have missed during CRP, what happens? My understanding is that this is going to be captured through the regulations, because liquidation is going to be considered as a extension of the CRP process, event-based. That means no resolution plan, hence liquidation.
Sir, in fact, even for CRP, there is an amendment saying about claims. In that, the word collate has been used again, and then an explanation has been used that word collate should be changed to verify. Otherwise, it may again fall
No,
back
no,
to
no.
usual level.
That there is an explanation which we covered in the first part, because that was probably you didn't join at that. Verification now includes the power to estimate the amount of claim. That is now got legislative
They
backing.
have put that in explanation, but ideally they should have put it in clause itself and remove the word collate.
Oh, ये lawyer वाली बात है कि does it have, some people say explanation doesn't have the same force as per the provision. That is not strictly true. That is a misunderstanding. Explanation is part of the code and it has the same force. Okay. Now this is important, please. Both important here. This is section 47. Okay. 47(1) is being substituted, and what happens is now if the RP or liquidator does not file an avoidance application, the creditor's member or partner of the CD has the power to do so. And if such an application by any of these parties is accepted, then the RP or liquidator, as the case may be, opens himself up to disciplinary action. It's there now in the section 47(3). A shall pass an order requiring the board, okay, to initiate. So it is not left to the board to decide. This is possibly the only place where the A is given a power to direct the board to initiate disciplinary action. Till today, it was not there.
Can I speak, sir?
Haji, yes.
I think in this provision, before any disciplinary proceedings are initiated against the liquidator, I think what they have missed out is they should give you a reasonable opportunity of being heard. Otherwise, the principle of natural justice will fail.
I think the way the wording is then of section this 47(3) and the way courts and tribunals practice in India, nothing will be done without hearing the party.
That is true, but I think in many places we find that that particular thing is mentioned in the law itself, which is being omitted here, which is not
No,
visible here.
yeah, see, it is not specifically there, but I don't think that's a problem. Maybe one can, when the regulations come, we can ask for it to be included there. It's easier to get regulations amended. That's why the regulatory power. Parliament meets once in a blue moon for a particular subject. So any change, getting it done through a proposed law
Why I'm
is
saying,
far more
sir,
difficult than regulation.
why I'm saying so is because it will be an order which is very prejudicial to the interest of the liquidator, because without his why he has not been able to do so, or with a proper
See,
explanation not being
yeah,
provided.
if you see this text itself, what does it say? After passing an order under subsection 2, that means first they have to accept the application of a party other than RP or liquidator for starting an avoidance proceeding. After that, where adjudicating authority is satisfied. Now, satisfaction is by practice defined in Indian law that satisfaction can be only be after hearing parties concerned, or where parties are not directly involved, at least the material on record. They have to
Hello,
it
sir.
has to be a reasoned order.
Hello.
Not an
Sir, there.
apprehension which we need to have. I don't think
Hello.
anything will happen.
Sir,
Boliji.
there should be a explanation is also there should be there. If the party which is creditor is there or other party should share the enforcer to the RP. If the RP is not taking actions on that in any information which is pertaining to the fraud or undervalue transaction or extraordinary transaction, then it should go to the court. Otherwise, it will be lot of time consuming and
Okay. So, okay, to answer your query, you read this subsection 3 again. After having sufficient information or opportunity to avail information. That means RP either had it or asked for it and got it, then and then only this will apply. If it doesn't get it, then it doesn't apply. That is the meaning of that
But it
sentence.
should be clearly mentioned
No,
that
in law, this is clear. Mr. Patwal, you ask any lawyer, he will tell you this is sufficiently clear. So, I can tell you as a trained lawyer that yes, there is clarity. No need to be apprehensive about that part here. कुछ नहीं होगा. Now, section 49. Okay, we need to know what is this 49. Okay, 49 is about transactions defrauding creditors. Okay. There seems to be a bit of a problem as far as this sorry. Just a second. Now, this additional of words or a related party of the corporator is, to me, it seems to be a problem. I'm not sure whether I'm right or wrong. But if anybody has studied this, can you please enlighten us if at all there is a problem or it's okay? Okay, if not sure, we will leave it and go ahead. But okay, section 52. This was a gap in the law. It was there in the SARFAESI Act, where it is of course 60%. So in case of joint charge or pari passu charges of more than one creditor, then at least 66% of value of those having security interest on that particular asset will need to agree for 52 to be invoked. This is clarificatory. Subsection 8. Again, there was an issue as to anybody who was invoked 52. Such creditor, what are the costs and charges that they have to pay? Now it's clarified. All that they would have paid in case they had not invoked 52, they will need to pay. Now, this is very, very, very important. In a way, this addresses to some extent Amit Metallics, TDB, the original judgment in SR, etc., etc. Indirectly, this is talking of ranking of charges. Okay. That's not mentioned specifically in the law, but this indirectly addresses that a secured creditor's security interest can only be to that value. So if you have, let's say 100 as your claim, but secured by an asset worth only 20, then only 20 is you are a secured creditor only for the 20 and not for the rest. The rest shall be considered as unsecured. So clarification again, rainbow. Okay. Following explanation under clause E of 53(1)(e). basically removes the confusion created by rainbow. This again illustration now talks of arrangement between creditors, whether it will have an impact on the distribution in terms of the ranking under 53. Yes, as long as it is between similarly placed creditors. No, if it is in relation to non-similar creditors. So there can be no arrangement between secured creditors and workmen, which will change the order of distribution under 53. But there can be between FC1 and FC2. And basically recognizing that there can be a ranking of charges. First charge, second charge, what we talk of, without using those terms, this is what it means. Okay. Now, in my opinion, this is the biggest problem. Okay, what is coming now in terms of liquidation period? 180 days, extendable by 90. Is it even possible?
It's not possible. In fact, maybe as that kept earlier, it should be directly a 2-year period. Unnecessary filing of applications, etc., should be avoided. If it finishes early, great, but it usually doesn't finish early. See, maybe the reason why they're saying they're reducing the period is now the claim verification is not required. You don't have to form SHCC. The same COC, etc., continues. But if the world was so simple, maybe we did not require IBC code itself. We should get practical. 180 days is not feasible, not practical at all. In fact, 90 days is required just for payment time. Second thing, even 1 year is not sufficient. It should be directly kept as 2 years. And also, just flash selling of assets may not always yield maximization of value that is required. Some strategy has to be in place. Some elbow room has to be given for different type of assets. And the assets will be scattered at different locations also. So this is my view.
Yes, please, others participate. This is important. All those who are doing liquidation or have done liquidation, please share your thoughts, because the way the provision is worded, you can at best get one extension, 270 days. You are unable to complete liquidation, then what? See, in case of CIRP, there is, the question, then what is liquidation? In case of liquidation, what after liquidation? It is not giving discretion for further period. It is not imposing condition. It's just saying 270 days, liquidation doesn't happen. It doesn't say what should happen after that. Because liquidation means it is only a question of harvesting of organs, right? Death is already done. Certificate is to be issued. So if the liquidation is not completed, will it be that liquidation is withdrawn and the company becomes live again? That is the unintended consequence of this amendment.
So if the assets are directly to go to creditors, why did you require liquidation in CRP itself?
No, that is even not mentioned. Forget creditors and all that. Okay. That is not. It is a provision which has not been thought through. After liquidation, what? If you don't have an answer to that, this provision is meaningless. And effectively, it is against law, because you can't have something which ends with nothing. It could be anything. They want to change the liquidator and say this liquidator is not good enough, we'll have another, fine. But you can't say that, this is the period, don't do it. I don't know what happens after that. And anything beyond this cannot be left to regulations, because this is substantive law.
So the fact is, even for liquidation, now we require for the manner of sale, the marketing strategy, the reserve price, etc., the approval of SHCC, which will now go to COC. Sometimes they themselves don't take decision for 2 months. A month or two passes on the decision making itself and decide them. Then we have e-auction. Now again the e-auction timelines are kept by IBBI, which are again non-feasible, non-flexible. In fact, the calendar which IBBI has given is practically not possible if Saturday, Sunday holidays which IBBI and the portal takes. You have to somehow fix in some violation here or there, which has already been informed to IBBI. So first, they are 35-day timeline, which is impractical, has been kept. Minimum 15-day open has been kept. Even in failure, it continues. Then you have to take COC approval. They don't take decision for 1 month to 2 months. And then you say you complete in 180 days and one extension of 90 days. Almost 99% of the cases will directly go to a dead end where nothing happens. Maybe this is what this provision will bring liquidation to.
Devang, you are talking of practical implementation issues in relation to people concerned, the stakeholders, how they. Most liquidations take more time because the assets are not saleable for a variety of reasons. And all your, even if you have the best COC, which will give you approval within 24 hours, everything. If this asset is not saleable, it won't get sold. Simple.
Agreed.
Liquidations don't take more time because of these issues. They take more time because the asset has inherent saleability issues. It could be the type of asset, the location of the asset, the quality of the asset, and the reserve price. And of course, factors behind the screen like, the looming threat of promoters who do not allow it to be sold without actually interfering, publicly. So, okay. So what, anybody wants to say anything more other than Devang? Devang, for next 5 minutes, you are not allowed to speak. Let's hear somebody. Have liquidators, please.
Maybe the intent is to, close the liquidation and go back to the realization under the surface C and other things. And, let the asset, there is a provision. Earlier also, there was a, provision of only 1 year. There was no mention of extension or anything. Now they want to distribute the asset back to the creditors and let them, realize it in whatever way, that is surface C or.
See, liquidation all over the world is understood to be the final step. There is nothing final beyond final.
No, but
Okay.
there is a provision of, distribution of unsold asset in the
That's different.
present guidelines.
That's okay. Then it has to see.
I
No
don't know
law.
what is the
Let me
intent. I don't know what
I-
is the intent of shortening the period, seeing the practically what is happening. I am handling a big liquidation, which is there for the last 7 years. There was a ED attachment, there was a CBI issue and all that. Of course, we got the exclusion period done for that. But once the assets become a subject of ED attachment, this and then the saleability also falls down. People, want to do business. They don't want to get caught into the, other things. So 7 years, we are not able to sell the asset because of one reason or the other. So I don't know what is the intent of, doing this. To my mind, what comes is that you distribute the unsold asset and let
no,
it be realized
don't
by the
don't
credit.
read. I would suggest don't read into the provision something which is not explicit. As a liquidator, with this provision, is it workable? If not, this is exactly the type of thing that is to be suggested, that this is not workable.
Yeah, it's not workable.
So
First of all, providing such a thing, going by the database which talks contrary to what is being provided.
not only that, liquidation is globally, other than voluntary liquidation, a court monitored process globally. Okay, there is no jurisdiction where liquidation can be done without the intervention of court, because it's a proceeding in rem and it has to be done only through a court or tribunal. Now, by saying that if it doesn't get done and without telling what is the consequence of that happening, there has to be, okay, not done. What next? It is
To file a closure and mention that this asset
no,
is
that's
being...
not told. So let's not read into something which is not there. They have to tell what next, right? A provision which says कि इतने में करना है. Okay, नहीं हुआ. Then what? It has to provide for that. Whatever it be. They can very well say, if they want to, Parliament has the right to say, you close the liquidation and it reverts back to creditors can take whatever decision they want. Say so. It's not said.
Yeah, yeah,
Not
that's
saying it means
of course.
it is
What is before us
the
is
law is
we all
illegal.
know, and
The law
the
is
one who
illegal to
has
the extent.
the one body, legal body who has framed this kind of amendment. I don't know what is the background and how they think about this.
Yeah. No, we have to look at it from our angle as to implementability. Can we implement it? No. Then we have to suggest that it is not implementable. Okay.
Yeah, of
So
course, it's not implementable.
that is the thing, that it's an unimplementable provision.
Sir, this is Kalol
Haji.
Bhattacharya. Can I speak a
Yeah.
little?
Oh yes, yes, please.
Yeah. Sir, I would like to just ask that
Hello. Hello.
laws in other matured countries, I mean, where the law has been implemented, is there somebody in this forum who has read it? Like in similar situations, what is the practice there?
Yes, anybody wants to answer that? If you are aware of anything, UK, Singapore, US,
Other
democratic
matured
countries.
organ
Yes.
entity in the matured laws in other countries.
Devang, wait. If nobody else
Am
wants to
I
talk,
heard?
then yeah, yeah, you have been heard. You have been heard. Okay, Devang. Specific, huh?
Process is cut in this particular manner. The court administrator continues with the liquidation even if it goes on for 10 years, even in the most advanced economies.
Yes, got the answer. That is also my understanding of law, that the liquidation being death, there is nothing beyond death unless you talk of reincarnation. Okay, so we flag it as a provision which is incomplete and unimplementable. Okay, now we come to the next one. Can you see the screen? This is, yeah, Deva.
Ravi Prakash, whoever is presenting from ICSI to parliamentary committee, the person needs to have the reasons for every this suggestion given. They are going to ask in parliamentary committee the reasons. So if, I don't know who will be presenting over there, but whoever is over there needs to know reasons also. If you are saying not implementable, the reason for non-implementation.
Yeah, of course. We have discussed it. This is being captured. This meeting is being recorded. I'm sure they will make their notes. They will discuss with IBBI separately, and probably it will be through IBBI that the representation. I'm not sure. Maybe the IPS directly, whatever it is. But members are, of course, being members of the institutes, the different IPAs, please respond and give suggestions to your IPAs also, where you are a member, whatever you want to say. Okay. Today we are talking orally, but giving in writing helps. Okay, section 54, the dissolution section. These were the first one we talked of, 180 and 90, and proceedings avoidance will continue. Now 1B. This is the new one. And this is talking of the leftover assets. Okay. Or rather, sorry, this is about any proceeding which is pending, which determines that, similar to what we talked of in resolution plan, that the committee will have to make appropriate arrangements so that outcome of litigation, whatever is to be distributed, is done in the as per section 53. Now, early dissolution. Now, this is what I think somebody was saying. What happens to the assets, if any? Now, obviously, early dissolution will be, it is expected, will be approved by the committee only when, the not many assets are there, if at all very minor, and going through the liquidation process is not going to be cost effective. So, if any asset is there, how it shall be disposed of and proceeds distributed, the committee has to provide for that. They can't just say early dissolution and मुझे नहीं मालूम बाकी का क्या होगा. Okay, I would now like to go with the CIIRP. Okay, the creditor initiated insolvency process. Okay, this is chapter 4A, new chapter totally. It is not totally new in concept. It is basically a modified PPIRP. Now, PPIRP was specifically for MSME category of corporate debtors. It had a certain process and procedure. Some experience being picked up from there. Now, this will be, of course, the type of CD that who will be covered, the class of creditors or category of creditors who can initiate, all are left to notification by the central government. So, this can be only initiated by a financial creditor. The RP is appointed by the FC. There is no requirement of going to the AA for getting the RP appointed or even getting the RP confirmed. So, if the creditor appoints it, such and such person will be the RP. Before appointing the RP, the initiating creditor will have to take approval of other FCs who have a vote share of 51% minimum. There is a provision to inform the CD of its intention to initiate this. There is a provision for the CD to make representation or objection, which is to be considered. Now, this is somewhat similar to SARFAESI. Some provisions are being borrowed from there, where the borrower can raise objection. They have to be considered by the initiating CD and then get an approval again. Second, so there are two approvals which the initiating FC has to take. One for appointment of RP and another for actually continuing or going ahead with the process itself. There is a time period, 30 days for getting approval of the other FCs. And if that is not received within that period, if the initiating FC or anybody else wants to again do it, they have to start all over again. So, in a way, the process of CIIRP lapses if the approval is not received within 30 days by the minimum FC by vote share. Here the RP who is appointed has to make public announcement about the process. Details will come in the regulation and communicate the same along with a report. Now, this is the important part. The RP so appointed will have to file a report with the A, confirming that the initiating FC has met all the requirements for initiating and continuing with the CIRP. The CD has a second option or of filing an objection, that is before the adjudicating authority itself. If such an application is filed and the AA comes to the conclusion that there was no default, or the CIRP which was started, CIIRP, did not fulfill all the requirements, then they can set aside the process. Time period 150 days, no extensions. Okay, there is no provision for that. Except once for maximum of 45 days. So the total extended period will be 150 plus 45 max, that is 195 days. The powers of the RP are limited, like as in the PPIRP. There is no taking control and custody because debtor continues to be in possession and control. No managing the affairs because that will be the existing board which will continue. Section 58F, subsection 2, important because the RP has been given sort of a veto power on the resolutions which are passed or proposed to be passed by the board of directors of that CD. Here, moratorium is not automatic. The RP has to apply for it. And of course, the moratorium starts from the date the application is filed. And if the adjudicating authority does not accept that application or rejects it, then it stops. Otherwise, like the interim moratorium provision in personal guarantor insolvency. So the moment application is filed for initiating moratorium, the moratorium kicks in. The CIIRP can be converted into a CIRP under certain specific conditions. And the AA can decide the stage from which this AA can decide the stage from which the CIRP shall start. That means it doesn't have to be from the first stage of calling claims, etc. It might be at a subsequent stage. A withdrawal of public announcement is the 12-way equivalent under normal CIRP. So if such an application is made, then the public announcement of commencement is withdrawn. And that is, of course, it has to be approved by the A, and the CIRP shall be deemed to have come to a conclusion. It has to be only after COC is constituted and before the first invitation for resolution plan. Now, this is aligned with the CIRP proposed amendments. Okay, so this is the creditor-initiated insolvency process. And from my side, that is more or less it. There are, of course, many other amendments which are proposed, but we do not have that much time to go into all of that today. Mem Participants, members, kindly go through them, and you can write to your IPA, ICSI, or anybody else with whatever suggestion you have, preferably backed by logic and reasoning. And request is to keep that representation short so that it is read, understood, and forwarded. Okay. Yes. Shaini Saab, you want to say anything? You are on mute.
Thank you, sir. Very wonderful session, sir. Thank you.
Thank you. Thank you. Yes. Anybody wants to say anything more? Add something? Of course, if you think of something else, please, as early as possible, write to ICSI, IIP, or to your own IPA, or both. And whatever you want to put across, please do so. Haji. Hello.
I will have more comments more on the regulations, but of course, this is not the right forum and
No,
thing
once
that.
the draft regulations come, I think we will be probably
Yeah,
spending
no,
much
on the
more
existing
time.
regulations. On the existing
Oh,
regulations in terms of implementation.
Okay.
So that is something that I will, of course, separately wish ICSI, IPA pursues. And uses this particular amendment to look at amending the existing regulations also.
Some of them will have to be just to align with the new regime. Yes.
Yes. Also, not only that, there are other regulations which there is a certain amount of ambiguity and contradiction also,
True.
which of course I will do at the appropriate time.
Zarur. I think Nitika ji,
Ravi
you could have a
Prakash,
session
what
on
is your
that.
view on this creditor-initiated insolvency process?
What is my view?
Yes. Is
I'm
it
not supposed to,
advisable, not advisable, positive, negative, anything?
as a moderator, I'm not supposed to have views, but now that the session is complete, now I can tell what my views are. If thought through and implemented, it is the best possible.
And what are the views of other participants? Yes, please, Ravi Prakash, you wanted to add.
Yeah, no, I want to say this that, okay, there were certain problems with the PPIRP, why it basically failed. And one of them was that provision which said that, what do you call that, operational creditors cannot be adversely affected by any resolution plan, which means basically that no plan which takes away their rights or diminishes it can be there. Now, I'm not seeing such a provision here. Okay. I would assume that that means that it can be an proper resolution plan, like any other normal CIRP, except that it is more closely aligned with Chapter 11 type of Chapter 11 of the US Bankruptcy Code, or the administration provisions under the UK Insolvency Act, which in general are found to be far better in implementation, because they all said and done. Of course, we are not talking of fraudulent accounts, but those accounts where the insolvency is a consequence of market forces or events which are largely beyond the control of the management. This is the best. It gives a restructuring mechanism which has the imprimatur of the court or tribunal, which will give a lot of comfort to all stakeholders. So from that angle, it's a very good proposal. How well it gets implemented, that is not the fault of the lawmaker. That is the fault of all those people who do everything possible to game the system, and which includes IPs, without excluding anybody from that. We know what is happening in that ecosystem. So that is what I had to say. Yeah. Anybody else, please?
Never the law. How do we correct the mail?
Yeah. Part of life. That's why we never have big bang reforms actually, except once in a while. Incremental is better than nothing. So if you look at insolvency law in India, the first two acts, the Provincial Towns or Presidency Insolvency Act, big failure, nothing happened. Then came SICA, largely a failure, again nothing. DRT, RDDB, etc., partial success. IBC is actually, compared to all of these, a resounding success. Today, I think all IPs can look at it, that the number of inquiries or even cases, EOIs for acting as IRP have come down drastically. So what is the reason? One, of course, the pipeline, legacy cases, they are all undergoing CIRP or whatever. But equally important is that today, most managements, most of them who have value in their company, still have value, are taking the initiative to approach their lenders to have a restructuring prior to or even before any insolvency action is contemplated. This happened. This is the reality. And I think, as somebody once said, we all know who, that the best use of IBC is not to have to use it at all. So the law has met its objective. Yes, some participants in this might have had problems and will continue to have issues. But the prime objective has been met. Discipline has started coming into the borrower community.
Thank you for your time. Thank you for your moderation, and thank you everyone, and thank you this ICSI for conducting this meeting.
Yes, thank you so much, everyone, and thank you, Ganti sir, for sparing your valuable time and for taking this session and for making everyone aware of all the amendments. And I would request all the participants to kindly share their suggestions if they have any through email, so that we can take that into consideration and send the collective views to Lok Sabha. So the suggestions can be sent by Monday first half, and email ID I have already shared in the chat box. So I would request everyone to give their valuable inputs. Thank you so much, everyone, and thank you so
Thank you,
much.
Ravi sir. Wonderful presentation, sir. Thank you, sir.
Thank you, sir.
Thank you all very much. Thanks a
Thank you.
lot. Thank you. Bye.
Thank you. Thank you very much.
Thank you, Aniji. Thanks for coming.
Thank you, sir.